Good evening. I'd like to call to order City Mayor Council. We're going to begin the 5:30 p.m. from our city solicitor, Delaware Freedom of Information Act.
Okay. Thank you. And if you don't mind reminding me how to, the presentation is loaded.
There we go.
All right. Well, good afternoon. Good to see you again. Can you see that okay? Good to see you again. I was before the council several meetings ago to talk about the Delaware Code of Conduct and procedural due process in certain hearings. And we decided to defer the FOIA presentation because that would take another hour or so. And so we decided to split it up, maybe 50 minutes. So we thought we'd just focus on FOIA today. FOIA, or the Freedom of Information Act, is an important statute. It's important that towns and cities get it right for a lot of reasons, and we're going to focus on that here today. Delaware's, sometimes FOIA is referred to as open meeting statute. Delaware's open meeting statute is called FOIA, the Freedom of Information Act. And if you wanted to simplify it and just sort of keep a mnemonic thing in your mind, what is FOIA all about? It's about public meetings, public documents, or open meetings, open documents. And we're going to spend most of the time this afternoon focusing on the open meeting portion of FOIA. I think it's important to understand in anything, but including in FOIA, what the purpose is. Like, why do we have FOIA? Like, why does it exist? And there's an important policy statement in FOIA that makes it clear why it exists. It's not just transparency for transparency's sake. A lot of people will say, oh, it's all about just transparent government. It's, to be sure, but it goes more deeply than that. It really goes to the essence of our democratic form of government and accountability. And so that's where the statement, I've put this up there, I'm going to read it because it's important. The policy behind Delaware's FOIA is, it is vital in a democratic society that public business is performed in an open and public manner so that our citizens should have the opportunity to observe the performance of public officials and to monitor the decisions that are made by such officials in formulating and executing public policy. And further, it is vital that citizens have easy access to public records in order that the society remain free and democratic. It's not just, it's democracy, it's not just transparency. Toward these ends, and to further the accountability of government to the citizens of the state, this chapter is adopted and shall be so construed. Public bodies is broadly defined and broadly construed. So the statute defines, and then you have the Department of Justice issues opinions, and sometimes it goes to the court. Usually does not go to courts. It's usually the Department of Justice who issues opinions interpreting Delaware's FOIA. And public bodies has certainly been broadly defined by the statute and broadly construed by the Department of Justice in their opinions. A public body is defined as follows. A public body includes any regulatory, administrative, advisory, executive, appointive, or legislative body of any political subdivision of the state. The city of Seaford is a political subdivision of the state of Delaware. That means any board, bureau, commission, department, agency, committee, ad hoc committee, special committee, temporary committee, advisory board, and committee, subcommittee, legislative committee, association, group, panel, council, or any other entity or body is subject to FOIA. And the statute also makes it clear that FOIA applies to any group that is supported in whole or in part by any public funds or expends expends or disperses any public funds, including grants, gifts, or other similar dispersals or distributions, or is impliedly or specifically charged by any other public official, body, or agency to advise or to make reports, investigations, or recommendations. Even an ad hoc committee with only the power to recommend to you, you set up a subcommittee, or you have a commission under your ambit that makes recommendations to you. If they're meeting in public, if they're a quorum and they're making a recommendation, they are subject to FOIA as well. So if there's a quorum of members present, there is a meeting of a public body. Now, here's where it gets interesting. As I said, the Department of Justice issues advisory opinions from time to time, or adjudications, I guess, quasi-adjudications on contested FOIA matters. You may be aware of this one. This one I don't think is too controversial. I don't think many people were surprised by this decision, but on May 28 of this year, the Department of Justice issued an opinion determining that the Association of Coastal Towns, or ACT, was deemed to be a public body and therefore subject to FOIA. And the DOJ concluded, reached that determination because ACT had been established by bodies established by the General Assembly, that is, was established by various towns. Public funds of municipalities were collected to support ACT and dispersed for its expenses, and ACT was therefore subject to FOIA's public meeting and public documents requirements. So fairly recent vintage. Even an association of different towns is subject to FOIA.
May I ask a question?
Please do.
So with ACT and with SCAT, it says that it's subject to FOIA's public meeting. So is public comment required?
Sure,
at
absolutely.
SCAT meeting?
Absolutely. We'll get into all the requirements, but absolutely. Once it's deemed to be a public body, and there's a quorum of that public body, and they're meeting for public purposes, FOIA applies. You have to be noticed.
Very good.
Public comment. A meeting, so we talked about public bodies. Now let's talk about a meeting. A public meeting is a meeting for purposes of FOIA. It means the formal or informal gathering of a quorum for the purposes of discussing or taking action on a public business. So let's just drill down on that a little bit. If you don't have a quorum, it's not a meeting. If you all happen to be together because you're at a barbecue, or you're watching a football game, or you're at a concert, and you all just happen to be together, there's a quorum of you, but you're not meeting for public business, you're here to have, eat or listen or whatever, that's not a meeting for public purposes. So the mere fact that you're a quorum of you together, that doesn't make it a meeting. It's only when a quorum of you gets together to discuss public business, okay?
So,
Yep.
how about if public business comes up in a discussion after some adult beverages?
Stop the meeting. Stop the discussion.
Okay.
Yep. And say, look, let's take that up. Let's take that up in a meeting.
Well, yeah. Remember the day of the signage out there at the hospital?
Yes.
Dedicated,
Yes.
yeah. That's why I was curious
People
about that.
approached you about different things.
Yeah.
So the general rule is, subject to very few exceptions, is that every meeting of a public body shall be open to the public, to answer your question. So if there's any doubt, you should construe it as a public meeting of a public body and follow the statute. Of course, the meetings must be held within the city. This basically says in statutory speak, or I guess in DOJ speak, what I was my football and concert reference. So here's the quote from the Department of Justice. FOIA does not prohibit members of a public body from participating in other groups or attending other functions, so long as at those gatherings they do not discuss as a quorum the public business of the public body of which they are members. So that's basically that was my example with the football game. The one caveat here, you don't want to be sneaky and try to get around the quorum requirement by having serial meetings or serial emails with individuals. If the record indicates that that's what's going on, that to get around FOIA, there were a bunch of individual meetings, but had they happened at the same time, it was a quorum, that would be a problem. So I would strongly caution you against any serial meetings to get around FOIA. Now, until a few years ago, at least in Delaware, the rule was, well, what right does the public have at a public meeting? Until a few years ago, it was, well, the public can observe and they ought to participate and hear and listen. But as of 2022, the Delaware FOIA was amended to make it clear that public comment is also a requirement for a public meeting in Delaware. So that's 29 Del Code 1004A2. A meeting that is open to the public must include time for public comment, not just observation, but comment. Now, you can put reasonable time, place, manner restrictions on the public comment period. The time for public comment must provide a meaningful opportunity for the public to engage with the public body, but a public body may impose reasonable time, place, and manner restrictions on the length of the public comment period and the amount of time allotted for each public comment. So every public body will do it differently. There's no magic rule. Some public bodies will put the public comment at the beginning of a meeting. Some folks will put it at the end of a meeting. Some cities will allow the public comment to happen during the meeting. I don't think the last approach is the best approach. I think at the beginning or the end is a far better way to control a meeting, and many cities and towns do that. You can put a reasonable time, place, manner restriction on the entirety of the public comment period, say 30 minutes, for example, which is what Wilmington does. That's what Wilmington does. Wilmington puts 30 minutes of public comment at the beginning of their meeting from, let's say, 6 to 6:30, and then they begin their meeting. And if the agenda has been posted, that provides a meaningful opportunity for the public to comment on the agenda. In addition to the aggregate limit, you can put reasonable time, place, manner restrictions on the length of any individual's public comment, say 3 minutes, for example, which is a common restriction. Okay? Any questions on that? Now, we've been talking about public comment during a public meeting. If you remember when I was before you the last time, we were talking about due process. A public hearing is different than a public meeting. A public hearing is, for example, if you have a Board of Adjustment hearing, for example, or a quasi-adjudicative meeting on a contested site plan or a subdivision plan or a rezoning request on an individual piece of property, for example. In those situations, and your code may require a public hearing, that's where all those due process requirements kick in that I talked about the last time. That's different than public comment under FOIA. A public hearing has a due process requirement that any member of the public who might be affected by a decision on land use, for example, has an opportunity to be sworn under oath and present testimony, basically. So just keep in mind that public comment during a public meeting under FOIA is a little bit different than a due process right of an individual to participate and give testimony during a public hearing at a Board of Adjustment meeting, for example. Does that make sense?
Yes, sir.
Okay. I'm not sure you guys do much of that, but you can have a virtual meeting if you want. Of course, that was very popular during the COVID era. And some public bodies still use virtual meetings extensively. Many have gone back to live meetings. If you're going to hold a public meeting virtually, the notice must tell the public how the public can monitor and comment and participate. The meeting has to have an anchor location, as in this room right here. All participating members and witnesses have to be able to simultaneously hear the comments of each other and participate. and the public has to be able to monitor and be able to provide comment in a virtual meeting.
Luke, Mr. Meta, sorry.
That's right.
Does,
You can call me Luke.
does the posting of comments in a chat on a Zoom meeting qualify for that?
It depends. That requirement that I was just referring to, all participating members and witnesses can simultaneously hear the comments of each member and each witness. So if that chat room is not visible to everybody, I think that probably does not qualify. I think what you want is, what most cities who do this is, if they do it by Zoom, for example, or Teams or whatever, Skype, that the witness, you might want to pre-register, and the witness then, he or she appears on the screen, and they're engaging virtually as if they were physically in the room. I don't think you want to do the chat room.
Okay.
Yeah, I wouldn't think that a chat stream would be what I would call meaningful,
Right.
a meaningful opportunity, because not everybody's going to see it.
I'm getting way out of my wheelhouse here, but I recall when we were trying to get into this, there were those issues with being able to open it up to just anybody out there. And I've heard some horror stories about towns that have been hacked during these things that, we don't do that. We have a different method, but just an interesting question. It does.
And towns, in terms of the time, place, manner restrictions, one reasonable time, place, manner restriction for a public meeting of your town is that whoever's going to speak is a resident or a property owner of your town. You don't have to listen to somebody from California.
Yeah, and ours requires in-person as well.
Yeah.
Our policy does.
And that makes perfect sense. All right. Unless there's any other questions on virtual meetings, we'll go to notice. This is pretty straightforward. I know you know this already, but all public bodies shall give public notice of the regular meetings at least 7 days in advance. From time to time, it either needs to be a special meeting, an emergency situation, for example, or a rescheduled meeting. And there the requirement is to provide notice of the meeting as soon as reasonably practicable, but no later than 24 hours. No later than 24 hours before a rescheduled or an emergency meeting. You have to also provide an explanation as to why this regular 7-day notice has not been given, which is hopefully pretty straightforward. And then obviously the agenda for a meeting, especially if you're going to put public comment, for example, at the beginning of a meeting, you got to tell people what you're meeting about. That's what the whole point of public notice and an agenda. So the meeting agenda must include a general statement of the major issues expected to be discussed at a public meetings. There's recognition, of course, that agendas are subject to change. Of course, that can happen, either an addition or deletion of an item or adding an executive session. And so when an agenda is not available at the time of the initial posting, 7 days in advance, agenda items may be added, but no more or no less than 6 hours in advance. If you're going to change the agenda, you can't add an item or delete an item. Well, you can't really add an item less than 6 hours before a regularly scheduled meeting. And again, you want your agenda to be informative. You basically want to tell your citizens what you're going to talk about. And so here again, there's a quote. Now this is actually somebody who knows what he's talking about. This is former Chancellor Allen, very distinguished jurist in Delaware. So this is important. So I'll just read it while this is on agenda specificity. So while the statute requires only a general statement of the subject to be addressed by the public body, when an agency, or in this case a body, knows that an important specific aspect of a general subject is to be dealt with, it satisfies neither the spirit nor the letter of FOIA to state the subject in such broad generalities as to fail to draw the public's attention to the fact that a specific important subject will be treated. So if you know that you're going to drill down on a specific issue, put that in the agenda. Of course, the notice has to be conspicuously posted. Public notice requirement by this section shall include but not be limited to conspicuous posting of the said notice at the principal office of the public body holding the meeting, or if no such office exists at a place where meetings of the body are regularly held, so you post them here in your front, you put them on your website, and so on and so forth. Let's talk about minutes for a second, and here I think many towns overdo it in minutes, in my view. If you look at the actual requirement for minutes under Delaware's FOIA statute, it does not require a verbatim transcript. In fact, I think there's a real risk of trying to, especially in today's world with so many things are recorded on video, but even without that, to try to record every statement that is made. Unless you're a trained stenographer, somebody's going to get it wrong. And there are other ways to capture what was actually discussed. So here's what the requirement is under Delaware law for meeting minutes. FOIA requires that the minutes only include a record of those members present, so who was there, and a record by individual members of each vote taken and action agreed upon. That's all that's required for your minutes. Now, you may want to be more expansive, but the basic minimum requirement for minutes for a public meeting is actually quite narrow. Again, does not need to be a verbatim transcript in my view. There are significant risks to a public body attempting to do a verbatim transcript because you can get it wrong. And it takes up a lot of time, quite frankly, for all of you to be reading the minutes and, oh my God, is that what I said and that what I didn't say? And that,
It's
you can
interesting you say that.
keep it simple. That's my view.
Yeah, because, one of the things we have some issues with sometimes is when public comment occurs. We try to get that as good as we can, but sometimes we don't. And, whether the microphone but we don't even have to put public comment items in the minutes.
Well, I think you should include a general discussion that there was public comment, and you can identify the name of somebody who was commenting, generally what they talked about, but I don't think you need to, and I don't think it's good practice to try to capture exactly what was said.
We have tried hard to capture exactly what
Yeah,
was said.
I think that's risky, and it's not required.
It's interesting.
I think it can be counterproductive, quite frankly.
Save a lot of data.
Yes, sir. Yeah. And now we record, there's a transcript, or not a transcript, there's a recording now that we keep. So
Well,
if anybody has any questions.
That is the key, and I think since towns have been recording their meetings, I mean, that is basically becomes the unofficial record.
De facto, yep.
And here again, a judge, another distinguished jurist here, has actually confirmed what I just said. Vice Chancellor Balick, in the Common Cause case, stated as to minutes, there is no clearly implied statutory requirement to summarize the subjects discussed with any degree of specificity in the minutes that FOIA requires to be prepared and maintained. Okay? So that's public meetings. Unless there's any questions, let's talk about executive sessions. So again, FOIA is broadly written and is broadly construed. If there's any doubt, you want your meeting to be open to the public. However, there are very specific examples and situations where a public body may go into executive session. That is just you and whom you invite, but not open to the public. Any exceptions to the open meeting requirements are to be construed narrowly. So their executive sessions are recognized, but they're not favored by the Department of Justice in their interpretation of FOIA. Open meeting laws are liberally construed, and closed sessions exceptions within these statutes are strictly interpreted to limit non-public meetings. And as we get into, we'll talk about another recent opinion by the Department of Justice that makes it very, very clear that they construe public meetings very broadly and executive sessions very, very narrowly. The most common exceptions to the open meeting requirement, or the most common bases to go into executive session appropriately. There are good reasons to do it. is to have a discussion of an individual citizen's qualifications to hold a job or pursue training, activities of any law enforcement agency in its efforts to collect information leading to criminal apprehension, the hearing of an employee disciplinary or dismissal case, and personnel matters in which the names, competency, and abilities of individual employees are discussed. There are others, but these are the most common ones. Just on this one here, again, the Department of Justice, they write a lot of these opinions. By the way, just a note on that: the Department of Justice is not. It's not a court, right? They have been authorized by statute to issue these opinions, but those opinions can be appealed, and they are not. They're not judges, so this is their interpretation of specific situations under FOIA. But in all events, the DOJ has construed this particular basis to go into executive session, personnel matters, in which the names, competency, and abilities of individual employees are discussed. The DOJ has construed that basis to go into executive session to only cover employees, but not independent contractors or third parties bidding for a government project. So if it's discussions about a potential contractor, you can't rely on this particular session. Some government bodies, particularly the state, as of course a public body as well, they exempt themselves from some elements of FOIA, but not others. But when the state bids out a public works project, they have a very specific section which makes sense, that you don't want the competing bidders to be able to see what the other guy or gal is bidding on. So for a formal competitive bidding project, for a public works project, for example, there would be the basis, at least until a decision is made, to keep the competing bids secret, or at least so that the bidders can't cheat, basically, by looking at the other bid. But once a decision is made, then the competing proposals become public, unless there's another basis to claim confidentiality, such as a trade secret or something like that. I had mentioned another DOJ opinion. This one, I think, unlike the other one I mentioned, unlike the ACT opinion, I think this particular opinion caught some people by surprise, and I would say many, many people, including yours truly, strongly disagrees with this decision. With all due respect to the Department of Justice, this has not been adjudicated by a court, but the Department of Justice in a city of Rehoboth Beach matter found FOIA violations on the following grounds. I'm just going to read these to you and drill down on them a little bit, because it's important. It's a very recent one, and it's gotten a lot of attention, and you want to be aware of that. The Department of Justice determined that a discussion of an individual citizen's qualifications to hold a job, remember that basis to go into executive session, does not include a discussion by a public body of a prospective employee's employment agreement. So in that case, the city of Rehoboth Beach was interviewing and considering whether to hire on a town manager who had not yet been hired, and there was a discussion about the employees, or that prospective employee's employment agreement. You would think that would be quintessential personnel discussion under FOIA. The DOJ said, no, that person is not a current employee of the city of Rehoboth Beach, so was not qualified for executive session. And they went on to say, and again, I want to be respectful of the Department of Justice and the process that they follow, but I think I'm one of many who sort of shook their head at the next statement in the FOIA opinion, or the DOJ opinion. Discussion of salary and other compensation, the DOJ stated, are not related to the individual qualifications to hold a job. Now, I think most people in the private sector would be shocked by that statement, and would disagree with that statement. I disagree with that statement, but I'm not a judge and I'm not the DOJ. So it's important that you know that the DOJ very recently has concluded that, state DOJ, that a discussion of salary and other compensation is not related to an individual's qualifications to hold a job.
I'm sorry, I have to interject. I mean, I've had people call in over the phone and they ask what your starting pay is, and the first words out of my mouth is, it depends on your experience and qualifications. So I totally get what you're saying.
Yeah. So it'll be interesting to see whether the state legislature clarifies that. That would be the best way, or somebody can appeal the DOJ to a court. And then the other thing that, in this next piece, again, with all due respect to the DOJ, seems sort of silly to me, but the DOJ also in this Rehoboth Beach decision said that the public meeting portion of a meeting before going to executive session should include an opportunity for public comment. Now, you have a meeting here today, later on, and it includes an open session and then an executive session. You've got public comment. The situation here was that Rehoboth had scheduled a specific meeting just for executive session purposes, not at the tail end or at the beginning of a regular meeting. It was a specially scheduled meeting just to go into executive session. And the Department of Justice concluded that if a public body meets to go into executive session, of course they have to always meet in public first and then vote in public to go into executive session. And the Department of Justice said there has to be a public comment on the vote to go into executive session before you go into executive session, if you do it as a standalone executive session meeting. To me, that seems silly, but what I think doesn't really matter. That's how it has been construed recently by the Department of Justice. So not an issue for you because you have already provided public comment in your meeting tonight, and it is on the executive session, which has been duly noticed, has been at the tail end of your regular meeting. So again, that's not the court saying that, but they are charged with interpreting FOIA, and that's their interpretation. Other bases to go into executive session that are recognized by the statute, by the courts, and even by the DOJ. Strategy sessions, including those involving legal advice or opinions from an attorney at law with respect to either collective bargaining, so negotiations with your unions, for example, or pending or potential litigation, but only when an open meeting would have an adverse effect on the bargaining or litigation position of the public body. Now, here again, the next two slides I think are pretty important because they summarize at least how the Department of Justice has interpreted in opinions the scope of this litigation exception, or the litigation basis to go into executive session. So if you're going to go into executive session on the basis of pending or potential litigation, a public body would have the burden of justifying the decision to meet in executive session. Simply rumored potential litigation is not a proper basis for going into executive session, according to the DOJ. The DOJ has said that general legal advice is not a proper basis for going to executive session. It's got to be tied to pending or actual litigation. And the DOJ has also concluded that reference to intense public interest or public scrutiny is not a dispositive basis for going into executive session. However, the next slide, the DOJ has articulated when it would be appropriate to go into executive session under the litigation exception. The potential litigation exception for executive sessions applies only when there is a realistic and tangible threat of litigation based on objective factors. There's got to be some indicia of such a situation might include a written demand letter, a notice of a threat to sue, or previous or existing litigation between the parties, or proof of ongoing litigation regarding similar claims. So it's got to be more tangible than just sort of speculative if you're going to invoke it. Interestingly, in one DOJ opinion, the DOJ did say that if a town faces vocal hostility to a proposed action from members of the public who had in the past demonstrated a willingness to sue, executive sessions would be appropriate to discuss the litigation vulnerabilities, that is, strengths and weaknesses of alternate positions. All right. Again, some basic ground rules for executive session. If you go into executive session, again, we talked about this earlier, you have to first meet in public and take a public vote to go into executive session. That vote's got to be done in public. The purpose of the executive session, as you've done tonight, should be set forth on the agenda. When you're in executive session, the public body does not vote. You do not vote in executive session. You only vote in public session. And no deliberations on public business in executive session. You can discuss matters within the ambit of the statute for executive session, but then you come out of executive session and publicly deliberate and vote as informed by the executive session. Okay? Any questions on that? It's really important. As you can tell, some towns have gotten tripped up on this, and you don't want to be in that position.
Could you just give us an example?
An example?
Yeah.
Yeah. So let me just give me 1 second. I want to be careful here. So let's say there is litigation. Or let's say, so you're involved in litigation and you're thinking about settling the case. All right? So you go into executive session to discuss the strengths and weaknesses of whether to settle the case. And that discussion is held in executive session. You talk to your lawyer. You might win this case. We might lose this case. Different dynamics of it. But the actual decision to actually settle it has to be done in public.
So,
If the decision is your decision to make. Now, maybe if the decision is not your decision to make, maybe it's the town manager or city manager's decision to make.
So
Then-
we can't make a decision among us and then go out of executive session
Correct.
and vote on it.
You discuss it in executive
But
session.
there's no vote or
You
anything?
don't vote
Okay.
in executive
Yeah,
session.
that's what I wanted to clarify.
So, Mr. Mehta, to use your example of litigation, and we've been involved in it, where we give our attorney instructions on what our tolerance level is
Yeah.
and what we're, we want you to go try to settle it for X number of dollars or whatever. Is it appropriate to come out of executive session and then have a vote by the public body to say, we approve the city solicitor to deal with this case as outlined in executive session, and that's the vote?
Well, yeah, so if you haven't settled the case, obviously you can't discuss in public what you're willing to settle the case for. That sort of defeats the whole purpose. So typically what happens is an individual, let's say it's you, might have the authority to provide direction to the lawyer as to what the settlement authority is. And you're not a public body, you're an individual, you're a body of one. To the extent that you as a body need to bless the settlement, which is often the case for many towns, that ratification should happen in public session. But obviously, you don't want to meet in public and tell the other side what your litigation position is. That's clearly not the case.
So the language has to be crafted in such a way that the council authorizes an agent to act on their behalf
Well,
without disclosing
Yeah, well,
the particulars.
again, so typically, typically, in litigation situations, an individual is designated as the one having the authority to provide the direction to the lawyer. Typically, the body is not micromanaging settlement discussions. What I'm saying is, if there has been authorization by an individual, say the city manager, to a lawyer to settle a case, or to try a case, or whatever, but let's say to settle a case, once the settlement has been reached, the settlement may be subject to approval, for example, and then it's a very common clause in a settlement agreement, for example, is to say that the settlement needs to be ratified by the public body, and that ratification decision, that's what happens in public.
Thank you. So we get into real estate negotiations, and we get into other
Union negotiations.
union negotiations, and we
Right.
in the past have given.
So be careful what you say. So remember, collective bargaining agreements are specifically exempt from public meetings. There's a specific section of FOIA regarding the CBA discussions. So strategies, so here, I'll read it again. So one of the most common bases to go in executive session is strategy sessions, including those involving legal advice or opinions from an attorney at law with respect to collective bargaining or pending or potential litigation. That's exactly what we're talking about. That's strategy. You know, what do we want our CBA with the police union to look at, or pending litigation that we're trying to settle? What's our strategy to settle? That is core executive session.
Well, my specific train of thought is we authorize, they come to us and they ask us, what's your tolerance level for a financial amount for them to go back and try to settle? How does the body in an executive session, without voting, affirm a cap?
Yeah, so I think I'd rather take that discussion up offline with you. I think the basic parameters are exactly as set forth. So the strategy can be done in executive, and should be done in executive session. I used to be the city solicitor for the city of Wilmington. All right, we negotiated many CBAs with the police and with the firefighters. All of the when there was a tentative agreement reached with the various unions, through my efforts and other individuals who are negotiating on behalf of the city, the tentative agreement then had to get ratified by the union, of course, and then had to be taken back to the city council and voted on and ratified by the city council. It's a very standard process, and I would encourage you to follow that process here. If you have specific questions, since we are in open session here, maybe we can talk about that one-to-one.
Well, no, I was just trying to get to the general operating conditions, just in general. The contract or developer A comes, or citizen A comes and wants to sell a parcel of land.
Okay?
And has a number. They come to us and they say, do you agree with this number? Or what should we offer? And we offer a cap. And then they go out and they negotiate not to exceed a cap.
Yeah.
I mean,
Unless there's a very specific, there would have to be a very specific basis to go into executive session for negotiating a real estate transaction. And I can quickly look, I've been contemplating that scenario coming here, but if you give me 1 second, I'll just check real quick. Preliminary discussions on site another basis to go into executive session would be B2, preliminary discussions on site acquisitions for any publicly funded capital improvement or sales or leases of real property. Preliminary discussions, okay? Similar to a strategy for a litigation settlement or strategy for a CBA negotiation. Preliminary discussions on site acquisitions for any publicly funded capital improvements or sales or leases of real property. There again, I did that for the city of Wilmington as well. Those preliminary discussions, I would run them, but when it came time for the actual agreement, either sale or purchase or lease of property, that ratification, that approval had to be done in an open session, and
So,
was.
My concern is not that.
Yeah,
I mean,
yeah.
I'm not arguing that. I'm just concerned about the mechanics of how the body, without voting, tells their agent to move forward.
Well,
You know, it's a chicken or the egg thing. You know,
right. So
how do
we,
you make
we
that
again,
decision without voting.
we can talk about that offline. I would say as a general rule, that is typically addressed when an individual's authority is clearly set forth either by statute or by some other express delegation of authority. So, for example, without getting into the merits of litigation or CVA or a real estate deal, you as a body could say, you know what, I want to delegate authority to our city manager to basically run the negotiations, and when he gets to a certain point, he comes back to us. That would be a logical thing to do. And that delegation you might want to do in public, probably should do that in public. But that's one way, and that's typically the way, because you don't want a body of, a public body of many people, negotiating as a body.
No.
You want to delegate that to an individual and then bring it back.
Well, could you discuss amount, and we want to stay in this certain range
So,
or not? Or-
so again, if it falls within the specific parameters of the executive session, so if it's a preliminary discussion for the sale of real estate, or if it's a strategy, sure, I think you can do that. But you can't, in executive session, vote or deliberate on your vote.
So we can give city managers authority to do that, and we want you to stay within these parameters and come back to us with
I
a
certainly think
solution.
that you can delegate to an individual, and I think you do that, and should do that in public. I think in executive session, you can talk about the strengths and weaknesses.
Okay.
I would need to think about and would caution against in executive session setting the parameters.
Not too many specifics.
Yeah, that's the way the statute is written,
Yeah, okay.
and I would urge you to abide by that. All right, any other questions on, we're almost done. I told you we'd be done by in an hour, and we will. So that's it basically on public meetings. The public documents discussion will be really, really short, because there's really not a whole lot to say, because it's pretty straightforward. Public records, I'm sure you're not going to be surprised to hear, public records are very broadly defined, and the exceptions, that is, what is not a public record is very narrowly construed. One thing, the point I wanted to make, so basically anything that's a document, an email, a text, a piece of paper, PowerPoint presentation, those are documents. What FOIA does not require, it's not an end run around the discovery process in litigation. So a citizen cannot basically do what's called an interrogatory through FOIA. So sometimes people will do this, they'll submit a FOIA request and they just ask a bunch of questions, say, answer my question. Well, that's not what FOIA is about. Remember, FOIA is about public meetings and public documents. So if you get a FOIA request for documents, and it's a public document and it's been an appropriate FOIA request, you've got to produce the documents. If you get a FOIA request that's basically an interrogatory, tell me this, tell me that, tell me this. That's outside the scope of FOIA.
And we don't have to create a document.
You do not need to create a document
Answer.
to be responsive to a FOIA request. You only produce actual existing documents. Okay? That's an important point
We
to
have
make.
had that where people would say, can you provide it to me in this way? And that, obviously that takes time, that takes effort, so we've denied those requests for that purpose.
As I said, the exemptions regarding what is a public record are very narrow and are generally narrowly construed. I think it's fair to say that in municipal government in the state of Delaware, if there's any doubt whatsoever in your mind, you should assume that your communications, unlike the General Assembly who exempts themselves from FOIA when they communicate with their constituents, you should assume that your documents that you generate, you should assume that they will be treated as public documents. And therefore, might show up in a newspaper or on social media or a website. I'm sure you know every city has to have a FOIA coordinator. One final thing, and this is, DOJ cracks me up sometimes. They have these rules of procedure that are actually not in the statute, and not many people are aware of. It's very difficult to find the DOJ's own rules of procedure, but these rules of procedure were modified on May 24, and I'll just read it to you. I mean, the public should know about it since the DOJ is operating on this assumption. Regarding FOIA petitions regarding public documents, according to the DOJ, the petitions alleging denial of access to public records must be filed within 60 days after the denial of the request. Otherwise, the DOJ is not going to consider an appeal. And similarly, as to public meetings, the DOJ's rules of procedure, it's not in the statute, but they've construed it as to their rules. They say as to FOIA petitions regarding public meetings, those petitions must be filed within 6 months after the alleged violation. That is, so if you had a meeting that happened 8 months ago and somebody said, oh, that should have been, it was a violation of the public meeting requirements, DOJ is going to say, wasn't within the last 6 months, we're not going to consider it. I don't think many people know about that, but it's an interesting set of rules to be aware of that they.
We were, yes. Yeah, I believe
So that is my 50-minute summary of FOIA, but I'm happy to take any of the further questions.
Any questions from council?
just one, and it may be something you want to talk about offline, but how does all this fit in with attorney-client privileged information?
Yeah. So, there was that one slide I mentioned that you cannot, according to the DOJ, go into executive session solely for the purpose of getting general legal advice from your solicitor. It has to be tied either to pending or potential litigation, potential land deal, or a CBA. I used to be Chief Disciplinary Counsel for Delaware. I am rabid about protecting the attorney-client privilege. There are ways to have discussions that are protected by the attorney-client privilege that are not in executive session but are still protected, typically one-to-one.
Okay. Thank you.
Question?
Vice Mayor.
Since this meeting is not part of the regular meeting, should there have been public comment offered at this meeting?
Well, this is a
This is part of the regular meeting.
this is part of the regular meeting, and it's
Yeah,
been
this is just-
noticed.
We just started early.
And certainly, there's a-
Okay, I'm
Same
reading,
agenda.
it says, calls the regular meeting to order at 7 PM.
Yeah, again, we did the same thing. It's on the same thing, but this is where we do regular
I
business.
understand.
Yes. Yeah, this wasn't advertised as a special meeting or an out-of-the-ordinary meeting or anything like that. I get your point,
This-
but
lots of towns will call a meeting like this like a workshop, but it's been publicly noticed. Obviously, if anybody's here from the public who wants to make a public comment, you should certainly give them that opportunity before you adjourn.
I have to tell you, I'm glad you came and shared this information, because I don't know about you guys, but I've gotten a lot of meat out of this that I think will be very helpful in the future.
Good, I'm glad it was helpful.
Quick
And
point
again,
of
if you've any follow-up questions, it's totally fine and appropriate, assuming that the town is willing to pay for my time. If you have individual questions, to call me up or directly one-to-one, and I'm happy to provide any further one-to-one guidance.
So since it's part of the regular meeting, and since public comment is acceptable at the beginning, middle, end of a meeting, if we adjourn now and come back later and have public comment at that time, we're still in compliance.
I think that would be fine. I think that would be fine.
Are you going to adjourn or recess?
Recess, excuse me.
Recess.
Yes.
Okay.
Who's currently our FOIA?
Coordinator? Annette Montgomery is, she has been for quite some time.
Keep
We are-
this thing cool.
Yeah, I almost did too, sir. We are also training Ms. Stewart, who is here this evening, so we'd like to have at least two with those skills.
The other thing here is, this is, again, more in the nature of a workshop, which is, this is a public meeting. But you're not deciding anything. You're just getting today. You're just getting information from me. But certainly, if anybody has any public comment, if you want to make sure that during the public comment period, when you reconvene, if people want to make public comment about my presentation, they can certainly do that.
Are there any additional comments or questions from council? Okay. At this point, I'll ask the motion to go into recess.
So move, Mr. Mayor.
We have a motion on the floor. Do we have a second?
I'll second.
Second by Councilman Quillen. All those in favor say aye.
Aye.
All those opposed? Okay, it's unanimous. Go on to recess. Thank you.